Mateka. We are come back to discuss the law. I'm joined by Counsel James. Counsel James, how are you doing? Hey, long time. Yes. We posted the 2 videos previously and people enjoyed it. There are those who say that we can do it in Uganda. Ngabo bagala tunyola amateeka mu Uganda. Nabo bagategeere bulungi abagoberezi baffe. Ngakubadde waliwo ebigenda mu maaso ebirala bingi naye leero ngamye nti kamanyigeyo ka video k'amateeka era tugenda kayitamu mpola mpola. Kakati olwaleero tugenda kutunula ku contract law. Contract, valid contract. Biki ebikola endagaano entuufu. Kiki ekyo mu Luganda? Biki ebikola endagaano entuufu. Endagaano zaffe zino ezitandikirwako tulina elements ziringa 6 oba characteristics oba future oba factors oba essentials of valid contract. Kati bitugenda okutunuuliramu batunatira okukola ebibuuzo. Kati kanso tunatira okukola ebibuuzo. So I want you to discuss for me the elements of valid contract. You discuss the element and its cases, probably with the other authorities like sections and the articles of the Constitution. Because on 20th we are beginning our exams.
Like though you've said, Council, what you are going to look at, our fellow viewers and people that are watching there, these are things that are needed for a contract to be called a valid contract, to be enforceable in courts of law. What are the things that must not be missing? These are the things that we are going to look at. Ideally, we are going to look at offer, we are going to look at capacity, we are going to look at consideration, legal intentions, and then we shall also look at consent and acceptance. Now, but I think when you're doing it in paper, the order does not matter. What you have first, what you feel like you put first, we can go with that.
Yes.
So we start with the capacity. We start
with the offer.
Now, when you look at offer,
what is the offer?
Yes, for us, even though we have sections and what, but we want to make it more simple and easier for every person who's there, so that he can easily pick it up. Now, in the layman's language, an offer, this is the willingness. Omuntu anochikolanga yagadde is the willingness of the offerer to the offeree to be legally binding on both parties. Now, counsel here, the word legally binding is the key. Not every offer is enforceable.
Yes.
An offer that is legally binding, it simply means it can be enforced in courts of law.
Yes.
Now, when you look at the willingness in the law, we can call it consensus ad idem. The meeting of the mind.
Yes.
I shouldn't be subject to be forced to enter into a contract. All right?
Nze nawe tulina okukanya.
Okukanya okwo kulina kubanga sikwa buwaze. Tolina kunkaka nguleta.
Our minds must meet.
Must meet willingly without being subjected to
kuza pen yeno
any force.
Nchikuguza singi 5 okiriza nange nzikirizo kikuguza.
Yes, that's the willingness. Now, remember we are saying that an offer, this is the willingness from the offerer to the offeree to be legally binding on both parties. Now, counsel, now these are the civil procedure rules. The moment I give you my civil procedure, the person who's giving the civil procedure rules, I become the offerer.
Yes.
You become the offeree.
Yes.
Now the civil procedure rules becomes the offer.
Me the receiver, I'm the offering.
Yes.
Okay.
You become the offering, I'm the offerer. Me the person that is giving you. Now what I'm giving you is what you call the offer.
Yes.
Now we are saying that offer must be legally binding, because not every offer is legally binding, counsel. For example, if I promise to give you the offer for lunch and I don't give you, can you sue me?
You cannot. I cannot.
If you tell me that, you know what, can you come and attend my party, and I say I will come and I don't come, can you sue me? No. So the word legally binding, legal intentions, which must be looking at the intentions of the parties. Are they intending the offer to be legally enforced, or to was just like maybe a family or domestic or friendly offer, which the law presumes that is not legally binding. Now, after understanding that, we are going to come and we look at, when you look at this offer, it can be made by mouth, it can be made by conduct, it can be made by writing. Yes. Osobola okuwandiika ate oba n'ebikolwa byo, conduct, your actions can show that you okkiriza. Is that it?
Yes.
Now, when you look at it, now we are going to come and we look at the types of offer. Of course, the other scholars will tell you implied offer, express offer, but when you bring them and you summarize them together, we shall find that it has 3 types.
Yes.
We have what we call a conditional offer.
Conditional offer.
We have a counter offer, and we have a cross offer. Now, when you look at a counter offer, cancel a counter offer. This is the negative response that terminates the original offer.
Yes.
Actually, it's an offer itself. It's a negative response that terminates the original offer. For example, cancel. This is the Constitution, and this is the civil procedure rules, right? And now, my original offer, I feel like council, I should give you the civil procedure rules and the act. That's my original offer.
Yes.
Now I will tell you, council, I feel like giving you I want to offer you my civil procedure rules. And then for you say, I have one. Instead of the civil procedure rules, give me the Constitution. Now you responded. It's a negative response to the original offer. My original offer was of the civil procedure rules, but you are terminating it. You are setting it aside, and you are creating your own offer of the Constitution. That's what we call a counter offer. It's a negative response to the original offer. Council, I'm taking you for lunch. This is the original offer, right? And then for you say, instead of the lunch, just buy for me the notes. I get me. You are terminating my original offer of taking you for lunch, and you are creating your own offer of.
What if, okay, yes, I accept that. What if I also say that I am selling this Constitution to you for 20,000, and you respond that no, I'm giving you 15.
Yes.
It's also that.
That's also counter. Yes, as long as there is a rejection to the original offer. Now, basing on your submission, council, I think we are going to look at the case of Hyde versus Rich.
Yes.
When you look at that case of Hyde versus Rich, yes, the defendant was willing to offer to sell his farmland at £1,000 to the plaintiff, who's Hyde.
Yes.
Now Hyde responded to Rich and he said, no, instead of £1,000, I'm buying it at 950 pounds. That was a counter offer. Because initially, the original offer of the seller, who's the defendant, wanted £1,000, and now the buyer is replying to buy it at 950 pounds. Therefore, the court said there was no offer. There was no contract. So that's a counter offer. It's a negative response to the original offer.
Which other case can support?
Of course, the locus classicus case is that case of Hyde versus Rich.
Yes.
That one is enough. We can go with that.
Okay.
Then we are also going to look at a cross offer. When you look at a cross offer, counsel, a cross offer, we Catholics, we believe in the cross, right? Now let's bring it in our normal understanding. A cross offer for it. Both offers are crossing each other. How? Remember, if the offers, one of the rules of an offer is that an offer must be communicated to the offeree.
Yes.
We shall be reaching there. Now, in cross offer, offers are there, but they are cross-passing each other. In this, both parties, they don't know that they are offering each other, meaning there's no acceptance. For example, I want to offer you my phone, but I haven't communicated to you. Remember, one of the cardinal point in offer is that an offer must be communicated to the offeree.
Yes.
Now, I want to offer you my phone, but I haven't communicated to you. And the same phone, you also want me to give you the phone. You want me to offer you my phone, but you haven't communicated to me. Meaning my offer hasn't reached you, even your offer hasn't reached me. Why? There's no communication. And since there's no communication, there will not be acceptance. In the normal understanding, council, I'm in Machindi. In the Machindi. Goli Chibuye. ngena ndinye motoka ngunonyeze chuye nenga sikukugambe mungena nzija kunonya nzija kuwa visit ate nawe nolinya okuva ekibuye okunonyeze machindi nenga nawe badeto na kunga mambo meaning for not wasinganyiza. That's what a cross offer, eh? Yeah, you didn't communicate to me, meaning I will not find you, and also me I will not find, right? Now offers are cross passing each other. Remember, for a contract to take place, all the elements of the contract must be present. Now if you have not communicated with the offer, meaning acceptance will be lacking, therefore there will not be a contract. Cross offer zona zeisinganya. Okay. Why? Because both parties did not communicate. And I think there is no place for that.
Yes, there's no place.
Right?
Then the condition.
Now, when you look at a conditional offer for it, in a conditional offer, this is an offer that is given subject to certain terms and conditions to be fulfilled. Into your offer weri nenge lino obukwakulizo butamuzi obujigenderako okujitukiriza okubera nti ddala yatuukirizidwa olina okusooka no making sure nti obutamuzi ezo. For example, I will tell you council, in case you pass your senior 6, I'll buy for you a phone, and I'll buy for you a phone and maybe a suit, right? Now, it's on a condition that for you to get a phone and a suit from me, you must have passed senior 6. That's what you call a conditional offer.
Yes.
I'm going to give you a job in my company,
yes,
on a condition, score a first class degree. Now the job is there on a condition you must have scored a first class degree. That's what you call a conditional offer. But now council, after looking at those types of offer, we are going to come and look at the rules that govern an offer. One of the rules that governs an offer is that an offer must be communicated to the general world, to the group of persons, or to an individual. And I think we are going to back it up with the case of Khalid versus Kabwe Small Company.
Yes.
And I will always tell our viewers that if you know you are there and you haven't really given much time to understand that case of Khalid versus Kabwe Small Company,
that is if you were a student of law.
Yes, you haven't appreciated what you are, even those people who are doing business law with those humanity courses. Then you haven't appreciated what you call the law of contract, because it's a locus class case. It's a locus class case in the offer. Now, when you look at that case, you remember we are saying that an offer must be communicated to the general world, yes, to an individual, or to the group of persons.
Yes.
Now, to the general world, I can say, whoever comes across my bag, I'll give you 10,000. Meaning, the offer have communicated it to the entire world. Whoever, whether you're coming from China, from Uganda, from South Sudan, from Rubirizi, from Gulu, anywhere, the offer is open to every person. Now, if any person comes across that bag, I can give that reward.
Yes.
That's why we say that any person who comes across this. Then, another one is that it can be communicated to the group of persons. To the group of persons, you specify that group. For example, I can say, any student of MOOC, if you come across my bag, I'll give you this reward. The offer has been communicated to all the students of MOOCs.
Yes.
A student from KI, from MTAC, from Victoria University, from Chambo, if you come across my bag, I cannot give you that reward. Why? An offer must be communicated to the offeree.
Because the communication was specific.
To the group of people who move.
Okay.
Then council, when we say to an individual, I'm specific to a person. Council Moses, if you come across my bag, I'll give you a reward. Other than Moses, if you come across that bag, I cannot give you that reward. Now, when you look at that case of Khalid versus Kabwe Small Company, the company advertised in the newspaper, and it says that whoever contracts influenza, whoever, meaning it was open.
Yes, the general public.
Yes, they were to give a reward of £100 per that person.
Yes.
So the company went ahead and deposited £1,000 in this bank called Alliance to show sincerity in the matter, or seriousness in the matter. They are not joking. Now, when Khalid saw the advert, he said, "Oh, this is a good business. he went and bought the medicine called smoke ball. After using it like the way they have prescribed, she still caught influenza. Now she said, okay, since there's a reward, let me go for a reward. When she went for the reward, the company brought three grounds of argument. One, the company said there was no an offer to Khalil. But council, remember, we are saying that an offer can be made to a general world.
Yes.
So the fact that the company had advertised and had said that whoever comes across whoever buys the medicine called smoke ball, meaning it was open. So you cannot object. The company was not supposed to bring that objection of saying that they did not communicate, but they had made it to the entire world.
They issued out a notice, a public notice to the general public.
Yes.
So Khalil responded. And fulfilled the what? The requirements.
The requirements.
Yes.
So that one, the company lost. Then secondly, the company had said there was no acceptance. But council, just know that acceptance is a positive response to an offer. And acceptance can be done by conduct,
Yes.
orally, and by writing. So the fact that she stood up and she went and bought the medicine, her conduct was enough, meaning she had accepted.
She accepted the flame.
The company lost on that ground. The third ground, the company had said, for us it weren't serious. It was just a mere trade path. We were just motivating people to come and buy the medicine. The court rejected. The court said, you cannot say that it was a mere trade path. Why did you go ahead and deposit £1,000 in your bank called Alliance? The fact that you deposited that money, then you are showing the legal intentions, you are showing the seriousness in the matter.
Yes.
Because, council, when you come back to our Ugandan society setting, we have MTN. It says that everywhere you go there's network. We call on MTN, we don't find network. Has anyone ever saw the MTN?
I don't think so.
Why? For them, they are just motivating people to come and buy the SIM
Their
cards.
products.
Come and look at this company called Akansa Retire Powder. They advertise and they say that once you put it in bins, they will taste like meat. I cook, you cook. We are also we are ever hustling with the cooking.
Yes.
But when you put that Akansa there, have beans ever tasted like meat? They are made beans with even they have been weevils, right? So the company said no. The fact that you went ahead and deposited £1,000 in your bank, then you are showing sincerity in the matter, seriousness. There were legal intentions there, so the company lost the case.
If a Catholic company had not deposited the £1,000,
Khalil was not going to win the case. Because, counsel, what you have to know, that for a contract to be called a contract, to be valid and enforceable, all the essentials of a valid contract must be present.
yes, including
Legal intentions. So, depositing the money, they were trying to show that if in case there is a breach,
they can be able
the contract can be enforced.
Okay. That's okay.
Then we are still on the rules of offer. Another rule governing an offer is that an offer must be communicated to the offeree.
Yes.
And I think there we shall be looking at the case of Fisher versus Nadak.
Communication of offer. Yes.
When you look at that case of Fisher versus Nadak, you are going to see that offer must be communicated. Now, a police officer communicated for the reward of any person who will apprehend a criminal. You get? Now, Fisher did not know about that offer. For him, after getting the criminal, he went and surrendered the criminal to police in good faith, without knowing that there was the communication. So after going back and reached, and then he told the people, you know what? I apprehended the criminal. Then those guys told him, go and pick your reward. The reward was there. So he went back, and when he reached there, but they told me that that you had given a reward. My people home have told me that there is a reward. The police refused to give him that reward. Why? The offer he did not know about the offer. Therefore, it was not communicated to him. For him, yes, he brought a criminal, but he apprehended that criminal without knowing about the communication of the offer with the reward. And then another rule is that an offer may be made by conduct, orally, or by mouth. And that one we said about it already, that I can say, please, I'm giving you my phone, mouth to mouth. I can write down, writing, order conduct. Just get the phone, I give it here, I go.
That is by conduct.
Just by conduct. Now, we have also another rule, council, that says that an offer must be accepted in the manner prescribed. We can look at the case of Adams versus Lindshell. We can look at the case of, there's that case of, is it called the case of Helson versus Henson. All those cases can explain that element. Now, when you look at that case of Adams versus Lindshell, it talks about postal rule, whereby postal rule goes with the letter writings, and we shall be looking into there in details in acceptance. You're going to find out that if I write to you, if I tell you, please come and apply for a job, but application shall be via email, then I expect you to respect that, and you apply via email, right? So if I say that, please, there's the offer, but acceptance is going to be done by email. So then let it be by email. Don't use WhatsApp. Don't bring it to my phone, my office, or don't even write.
Or even a phone call.
A phone call, no. Just write it via the email.
Oh, that is responding to it as prescribed.
As the parties had agreed. So if I say, please call on my Airtel, even if you have my MTN, even if you found out that I'm online, don't WhatsApp me, don't call on my MTN.
Even me, there are some people who calls me on Airtel and I don't pick. When I told you call on MTN, I know what I'm doing.
So these are colleagues, these are things that we are trying to look at now. There, council, we shall come and we look at termination of the offer. How can it be terminated?
Yes.
We are going to look at a revocation. I think a revocation is under Section 4 of the Contract Act.
Section 4.
Yes, revocation of the acceptance. That's what it says, I think.
Section 4. Revocation of offer or acceptance. Yes.
Now, in the simple terms, when I try to cut it down, a revocation, this is whereby the offerer, he withdraws the offer from the offeree before the offeree makes an acceptance.
The offerer
withdraws the offer from the offeree before the offeree makes an acceptance. For example, council.
Anguza civil procedure rule. Okyusiza ebirowoozo bino okisazaamu nganze kuguza sinabakukiriza.
Chebaita revocation. When civil procedure rules, then remember what they are accepting, and you said acceptance can be by conduct, orally, or in writing.
Yes.
You had not done any of the three.
Yes.
Then I change my mind and say, that's what you call a revocation. So this is whereby the offerer withdraws the offer from the offeree before the offeree makes an acceptance.
Kati singa mba ngambye nti nzikiriza kyonguza.
Then
the contract is there.
It has been executed.
So if you revocate it, I sue you.
In revocation, the most important thing is acceptance has not been made.
If you revoke after my acceptance, what
then
happens?
There's a breach of contract.
There is a breach of contract.
And under Section 6 of the Contract Act, then you are entitled to be compensated what you got damages.
Okay. Wakati no mwabakoleye endagaano mwino okumanya.
Bano kwanga
oli wabakiriza kyogenda okumuguza ate gwe ne weekyusa akirizibwa okuwaabira. Kitegeeza?
Yes.
Now obadde okkiriza mu kukkiriza kw'endagaano eyimiriddewo.
So tugenda kuddamu tulabe another way how an offer can be terminated. What we are looking at, those grounds that bring an offer to an end, termination of the offer. Then
tugenda
offer. Tugenda kujja kati tutulire kye bayita counter offer. Now eno counter offer egwa types of offer nedamu negwa ne termination of the offer. Remember, basing on the case of Hyde versus Rich, tubadde tumaze okwogera, we had earlier said that a counter offer, this is a negative response that terminates the original offer.
Hyde versus Rich, oli yagamba nti faamu njitunda paundi 10,000.
Yes.
Onagamba nkuwa 95. Definitely, the original offer was terminated.
That's why even the defendant went and sold the farm to another person. But this person did not accept positively. So is rejection or is negative response to the original offer of £1,000 and creating the offer of 950, then it had terminated the original offer. That's why the defendant, the seller, had to change his mind and go and sell it to another person.
Yes.
So we also have a rejection. Now, cancel. A rejection. This is whereby the offeree rejects an offer from the offerer. And when civil procedure rules, no, please, I have one. Or I haven't reached there. I don't need the civil procedure rules. Chibaita rejection.
I've rejected it.
When question to no gamba to chagala, chibaita rejection in simple way. Can I take you for lunch? No, I'm satisfied. One no gamba, I'm fasting. That's what we call a rejection.
You're rejected.
Yes. Then we shall also look at what we call death. Death over insanity. But Council, do you know that death it also falls under frustration under section 65 of the Contract Act? Remember, a frustration, this is an occurrence of what? Of an event. Ntuwalo echintu ekibaawo nechukulemesa fulfilling a contract, and death is one of it. We've agreed I'm going to meet you tomorrow at 2, right? And then today before 2 reaches, as I'm going, then the car knocks me and I die. So my death will bring our meeting to an end.
Section 65.
Frustration.
Discharge by frustration.
So frustration tugenda kwa tulabira mu death, tugenda kwa tulabira mu destruction of the subject matter, act of God, supervising illegality, all those ones. So death, my death will bring a contract to an end. I agree tomorrow I will come to and meet you and sell me your car. Yeah? And as I'm on my way, I get an accident and I die. My death will bring the contract that we, the argument that we had made come to an end. Then tuna nature chibaita lapse of time. Obude ekakuzanyisa obude. So anti-time is also a key factor that brings an offer to an end. How does it come? Council, I will tell it, please make sure that by December you are done with the construction of my house. And then December clocks, you haven't constructed, right? You haven't finished.
Yes.
Then the contract can be terminated by lapse of time. When you look at that case of Ramsgate, when you look at that case of it's called Ramsgate Victoria Hotel versus Montefiore. In that case, this person was willing to sell the shares, I think by June. And then this person came around past June. Was it in November? And that's when he wanted to come and buy the shares. Then the seller said, please, the offer is already terminated by lapse of time. You see, there's a reasonable time. I was willing to sell the shares in June, but you are coming in November. So the offer would be terminated by lapse of time. So colleagues, we are trying to look at the elements that are needed for a valid contract to take place. And now I can say we've covered offer. Now let's look at acceptance, Council.
Yes, acceptance.
When you look at acceptance, Council acceptance, this is a positive response to the original offer. Meaning it can't be a rejection. A positive response to an offer. That's what you call an acceptance.
Okuddamu okutuufu eri kyonguza.
Okukiriza. Nti bompa ekintu nenzikiriza dekyo bayita acceptance. Oba bwe nkugamba ekintu nokkiriza positively bw'okigaana ebeera rejection. Now acceptance eno Council ekolebwa etya? Egenda kukolebwa by conduct. I come to visit you, then as I'm seated in the dining room, you bring me food.
Yes.
I start eating. I've accepted by conduct. Or I come and I tell you orally, can I get for you what to eat? Yes. Or I write to you, please, can I bring something for you? You respond back, yes. That's what you call acceptance. Now, acceptance no. Also this acceptance, it has rules that are governing each council. One, acceptance must be communicated.
Just like offer.
Yes. If you don't communicate your acceptance, either positive by conduct orally or in writing, then and you keep quiet, your silence does not amount to an acceptance. So silence will not amount to an acceptance. We are going to be looking at the case of Fit House versus Bindley. When you look at that case, counsel, the defendant was willing to sell his horse to their nephew at 30 pounds and 15 pence.
Yes.
And then he told this guy, the plaintiff, that if I don't hear from you, I will take it to be mine. And the plaintiff kept quiet. So when he kept quiet, this person went and sold the horse to another person. After selling, and this person discovered that the horse they had offered to him was being sold, he went and sold. So the issue before court, remember we had said earlier on that issues, these are grounds or these are matters of contentions. Chechi kutwala mu court, chechi kukayanya. Obutakanya buviridewa. You get. So now the issue before court was whether his silence had amounted to an acceptance. And the court said no. You are keeping quiet.
Does not amount to acceptance. Therefore, you have no case.
You have no case to answer. Toka. Dayo.
Okay.
Then we shall also look at another rule of acceptance, is that acceptance must be communicated by a person with authority. Nti omuntu alina okudamu acceptance anokubanga dala akirizibwa okugikola. And we are going to back it up with the case of Powell versus Lee. When you look at that case of Powell versus Lee, you are going to find out that the organization of Lee, it was calling for the people to come and apply for the position of the head teacher.
Yes, of a certain school.
Of a certain school. And when the Powell saw that advert, he went and applied. And when he applied, the internal management, the board,
yes,
the guy applied, he did the interview, he was shortlisted, and the internal management, they agreed to employ him.
Yes. But
they had not communicated to him officially. Now, one of the people that was in the organization called Kato, who was just a mere driver, you got the news that the management had agreed to employ him. But remember, the management had not communicated to the applicant officially. So, he again an alcohol rugambo. He went and broke out the news to yagenda namugamba omulimu bakuwadde the management have agreed to give you a job. So this guy, he also sat and
wait for their communication.
No, this guy had communicated. So for him, he thought that now he is the employer of he has been employed by the company since they had communicated to him.
Yes.
Now, later on, the organization, they changed
their position.
In their position.
And
shortlisted
another person.
They advertised. And another person applied and he was shortlisted, and for him, they communicated to him officially. So after communicating to him, Powell waited. He's not hearing any news from there. He still has the news from Kato.
Yes. Wanje mukulu. Mwendi ngenda kujja. Naye tunabeera ku time because saa 11 nja kuba nina engagement endala. Saba tukitambuze mu bwangu. Kale. Yes, let's proceed.
So, Madam Kugamba, now, when another person was communicated and Powell learned about it, he went and sued. They have terminated him from the job. So the issue before court was whether the person that had communicated Powell was authorized to do so. And then the court said no.
So being that The communication was made by a mere driver
who was not authorized
yes.
to communicate. Then there was no acceptance.
There was no acceptance.
So
yes, there was no contract. Okay.
Then, council also another rule is that acceptance must be made in the manner prescribed. Acceptance must be made in the manner prescribed. Now, in that, I think we are going to be looking at the case of Adams versus Lindshell. And if I tell you, please accept via my MTN, you accept via MTN. If I tell you, please accept via a postal address, accept via a postal address. Now, when you look at that case of Adams versus Lindshell Council, acceptance in postal rule is only becomes effective when the receiver receives the letter of acceptance and he writes back and then he drops it in the post box, or he gives the letter of acceptance to the post official people. Then acceptance will take place, even though me, the person that you are writing to back, I haven't yet received. Acceptance is there. But for the postal rule in acceptance to take place, 3 major conditions must be fulfilled.
Yes.
1, the letter should be well addressed.
Yes.
The letter should not delay, and the letter should not get lost.
So how me who responds, how can I guarantee that?
Now,
because me I stop on putting it in the right address.
Now, let's explain more about the postal council. I write to you as my colleague, and now I've given to the third person, okay, to the post official people,
yes,
or I've
to transport it.
Yes, to you. Now, the moment you receive that letter,
yes,
that one does not mean that acceptance has taken place. No, but the moment you receive, and then you write to me back, and then you drop it in the post box like this, then the postal rule has taken place, acceptance has taken place. But we are saying 3 major conditions must be present. Yes. 1, the letter should not get lost on the way. The letter should not delay, and the letter should be well addressed. Of course, when the letter is well addressed, it will reach me. The letter when it's not lost, it will reach me. And the letter when it's not delayed,
it will also reach. Oh.
You get? So if those things are not there, then the postal rule will not take place.
So Adams versus Lindshell. It's about the postal rule.
It's the postal rule. It also explains that that acceptance must be communicated in the manner prescribed.
Yes. Okay.
Then also, acceptance council must be qualified and absolute. When we say that acceptance must be qualified and absolute, it simply means that it shouldn't be leaving there any room for negotiation. Now, we shall also back up with the case of Hyde versus Rich. You see, in that case of Hyde versus Rich, there was negotiation. The person said he's selling the farm at 1,000 pounds.
Yes.
But then this guy is leaving there room for negotiation. He's saying, instead of 1,000 pounds, I'll buy it at 950 pounds. So that's why the seller, he rejected and he sold it to another person, because this person, he had created a room for negotiation. So acceptance must be absolute and qualified. It shouldn't be leaving there any room for negotiations.
Okay.
That's what we can talk about.
I think let's finish with the consideration. Next time we shall talk on
we shall look at legal intentions, capacity and consent. Now, when you look at consideration, in law, consideration we call it quid pro quo. Something for something. Way. What both parties suffer, what both parties obtain. In contract, every party must obtain and every party must suffer. Yes. When you look at the case of Churi versus Misa, consideration is defined as a variable right, interest, gain, profit.
Sure, I have that case here.
That is acquired, or you can call it a forbearance, a detriment, a loss that is suffered. Meaning, in consideration, both parties suffer, both parties obtain.
Churi versus Misa.
Yes.
Okay.
But now, counsel, in the layman's language, you can also define consideration as a promise from the promisor to the promisee to be legally binding. Meaning, every consideration, it must be having illegal intentions, and even it must be lawful.
Every consideration.
Yes.
It must have a legal intention.
Yes.
Okay, and it must be lawful.
Lawful. After understanding that, counsel, we are going now to look at types for consideration. There are three. Executed consideration, executory consideration, and past.
Executed, executory,
and past consideration. Now, when you look at executed consideration, this is a type of consideration that takes place there and then at the time of making a transaction. That's executed. It's a type of consideration that takes place there and then at time of making a contract.
For example,
how much is the civil procedure rules? 30,000. I give you 30,000, you give me the civil procedure rules. The contract has been executed.
Executed.
Consideration has been executed.
What the sentence?
Tell abanja mune. There's no any further obligation that I'm going to perform there.
Yes.
Kawedem.
Executed.
Consideration. It takes place there and then at the time of making a transaction.
Yes.
Then, when you look at executory, now executory consideration, for it, one of the parties has a future obligation to perform.
Yeah, executory
consideration.
Yes.
For it, this is the type of consideration whereby one of the parties has a future obligation to perform.
One of the parties has the future obligation to perform. Nti side yemu eino obuvunanyizibwa bw'okutuukiriza gye bugendako mu maaso. For example, how much is this civil procedure rules? Yes.
30,000. Madam, I have 20,000 right now. Can you give it to me, then I bring the 10,000 later? Meaning I have a future obligation of bringing the balance of 10,000 to make it 30.
So in any case, you are saying that if you are selling me anything and I pay you less money, the remaining balance is the future obligation.
Meaning I have a future obligation to perform or bring in the balance. Or even you may be like maybe let's say you are selling tomatoes, right? And then I tell you, oh, how much are those tomatoes? A basin is 10k, right?
Yes.
And I say, okay, do you know what you are going to do? Can you go and first wash on those tomatoes and remove the tomato medicine that they normally spray?
Yes.
Meaning you have, before you deliver, make sure that you deliver them in a good deliverable state.
When they are clean.
You have an obligation to do on a contract.
That is
That's executory consideration. One of the parties has a future obligation to perform.
Okay.
Now,
Past consideration.
Now, counsel on past. I want you to listen painstakingly on past. Past consideration is not sufficient consideration. Nti yo mu mateeka, past consideration, the general rule, remember the general rule of consideration is that consideration must be before, not past. But now, where past consideration is being accepted and taken as to be a consideration, parties must first agree on it before making a promise, before making an act. Musoka tikanyao ko nga temunatuukiriza kye mulina okola ku contract.
Yes.
Musoka tikanyako. I think counsel on past consideration. Are you seeing on the constitution?
Yes.
When you look at article 121, clause 4, paragraph A, it talks about prerogative of mercy. And on clause 4, 121, then clause 4,
prerogative of mercy.
Now when you go to clause 4, paragraph A,
clause 4, paragraph A, the president may, on the advice of the committee, grant to any person convicted of an offense a pardon either free or subject to lawful condition.
Now, my viewers may ask, why are we going in a constitution? There's what we want to explain. Now, on past consideration, parties first agree on it. Remember Balaam, when these Nup guys were being taken to
some of them, they are still in Chicago.
I remember Balaam came and told them that, please, can you accept the charges? After accepting the charges, the president will pardon you. I get him.
Yes.
Meaning, before they accepted on the charges, they first agreed about it that once they accept and they are given a sentence, then the president will intervene. Now, in this past consideration, we are going to be looking at the case of Lampling versus Brightwhite. In that case, it's related to this, pardon. Brightwhite had killed someone. And remember, under Article 22 of the Constitution, no one has a right to terminate someone's life, except when that person has gone through a court trial with the court of the competent jurisdiction. Meaning it's only court that can terminate your life, like what happened to Okere Nigaba.
Yes.
Besides the court, no one has that right. Now, when Brightwhite killed a person, he was sentenced, he was convicted and sentenced to death.
Yes.
I think that's murder, that's section 171 of the Penal Code Act, and then the punishment is under section 172. Now this person was given a death penalty. Now, when he was given a death penalty, it was waiting now for the king to sign. Like right now, we are waiting for the president to sign for Okero. Right? But though I hear that Okero has appealed about that sentence. Now, when this guy Brightwhite killed a person, he went and he was convicted and given a death penalty. He went and told it to Lampling. Lampling was a friend to the king. Remember in the law, when you look at under section 13 of the Contract Act, we have what we call undue influence. Someone who's in the superior position, he can use that position over over people who are in the lower position to get advantage over them, right?
Yes. Now,
when you look at that case, after Brightwhite killing a person, he went and told Lampling, you're a friend to the king. Can you go and talk to the king? And he pardons me. In the case I get a pardon from the king, I'm going to give 100 euros. Now, they agreed on it before making the performance of going to the king. Now, this guy Lampling successfully went to the king and convinced him, and indeed he was pardoned. After being pardoned, he came back demanding for the 100 euros that Brightwhite had promised him. Immediately, this guy said, me, I'm not giving anything.
Innocent.
Hey, but the court rejected. The court said no. Before this person going to the king, even if it's a past consideration, but you had agreed on it before making the performance. Therefore, you must be paid.
Therefore, you pay him.
You pay him. So that's how
in any case, you are saying that past consideration, you cannot do anything without agreeing with me before.
Inti inze bwankuleke waka, and then you are anaskali. You go and wash my car. Before I told you to wash it, after washing it, I come back and I find that the car is very good, looking nice. Okay, you wash the car. I'll buy for a cigar and wallet because that's what those people most times want. Now, if I later on decline and I refer to buy for him that promise I had made, he cannot sue me. Why? He washed the car before I instructed him to do so.
Okay.
Now
there was no agreement.
Yes. The promise is coming after. When the act has been made. Council, I want us to look at now rules governing consideration.
Yes, rules.
And I think we are going to look at I think like 4 rules. 1, consideration must be lawful, consideration must be sufficient but no need to be adequate, consideration must move from the promisee to the promisor, and consideration must be before but not past. Now, let's start with consideration must be lawful. Council, neither way, you cannot tell me to go and do something that is not accepted in the law.
In the law.
It's not allowed. It's not allowed. Murder is not allowed. You come
so the case of Katoka Jubi can apply here, even if it is a criminal case?
It can apply. It can apply, but
Katoka Jubi sent someone to kill.
Yes, it's not allowed, right? So it was still also a contract. Yeah, it's not allowed. So these are the things that we are going to look at. Now, let's start with this rule. Consideration must be lawful. We are going to apply the case of Foster versus the scholar. We can apply the case of Dan versus Cousin. We can apply the case of Order versus Martin, Fatadon versus Rogers, Parkinson versus the College of Ambulance and Harrison. There are very many cases, Council. Now, you're going to see that those cases, okay, you go in illegality, you pick those cases. Something that is illegal, meaning it's not accepted, right? Now, when you look at the case of what? Which case can I explain using it?
There is the other case of illegal selling of wine.
The whiskey. That's Foster versus the scholar.
Yes.
Now,
can it apply?
Yes, it can apply. Remember, there was a prohibition. For example, right now, the president has issued an order that those people who are coming for pilgrimages, who are coming for Namugongo,
yes,
don't come. Now, for if you insist,
because of Ebola,
and you insist and you come, then we shall say, please, what you are doing is not allowed. The president has stopped. Like what we had in COVID. So now, you're going to see in the case of Foster versus the scholar, there was a trade restriction of whiskey
in the US.
And the US to UK. Now, these two parties, a seller and a buyer. Remember, Council, when you look at sales of goods under Section 2, Subsection 1 of Sogisa Cap 292, a contract of sale of goods, this is whereby the seller, he agrees to transfer the property in the goods to a buyer for money consideration called price. And remember, transfer simply means ownership. Yes. And in law, we call it nemo that quid in habit. Because you cannot sell what you don't possess. Yes. Now, these guys, they were aware that there was a trade restriction of selling of whiskey between America and USA. And they insisted and they entered into a contract of sale. Now, one of the duties of the seller, a seller has the duty to deliver the goods to the buyer, right? So if the seller refuses to deliver, under Section 62 of Sogisa, then he has breached the contract. Now, when this guy came reached for delivering the whiskey, he could not deliver because there was the roadblocks, the restrictions. He failed to deliver. Now, when he failed to deliver, the buyer came and sued him.
That you failed to supply me.
Under Section 62.
As we agreed.
As we have agreed. But then the court said, please, you cannot sue this person because what you are doing is illegal. It's being prohibited by the law.
There was no contract.
Therefore, there was no contract. You cannot enter into a contract that is unlawful. Okay. Under legality council, you cannot recover anything that is illegal. If I try to go and kill someone and you go and you kill, and then I had promised you money, you come for it, I don't pay you. We all have a case. It's not allowed.
Okay, that is rule number 1.
Rule number 2, consideration must be passed. Consideration must be before, not passed. What does it mean? Into consideration should come before or at a time of contracting, but not after.
Except in the other case.
Except in the other case of Lampling versus Blight-White.
Yes.
But here we are going to be looking at the case of Remarcado. In the Remarcado case, the relatives who are staying abroad, right? The relatives were staying abroad. Now, this person who was staying within the country, he went and renovated the houses of the relatives before they had instructed him to do so. And now, when they came back in the country, they were so excited to find that the house is looking so nice, as if people were staying there. The paint is on point, everything. So they told this guy, boss, how much did you spend on the renovation? I spent this amount. So they said, okay, we are going to pay for the expenses that you spent. But remember, they are promising him to pay when this guy already had renovated the houses before they had instructed him to do so. You get? Now, later on, when they failed to pay, he went and sued. But the court said, no, please, your consideration is passed. And of which being passed, you do not agree on it. And the general is that consideration must be before, but not passed. So he lost the case.
Okay.
Another rule, we are going to look at the rule that says that consideration must be sufficient, but not need to be adequate. Consideration must be sufficient, but not need to be adequate. The law is interested, the court and the law is interested in the sufficiency.
Is there something valuable?
Did you agree on it? Was it sufficient to you by the time of making a contract? But the law is not interested on the adequacy. Was it really fair? Is it having really a genuine value? The court is not interested on it. The court for it is interested in the sufficiency. For example, counsel, if I get my phone and I tell, please, give my phone, or even just give me a bottle of water of 500 and I give a phone. But by me doing that, I'm looking at that bottle of water to be sufficient into the phone. But it's not adequate, right? So the law is not interested in the adequacy of the contract. Therefore, the law is very clear that if we make a bad bargain,
it is your problem.
The court expects you to maintain and stick with that. Bobo bargaining obubi. Court evere kusubiramo no maintaining echo. And if you get your car, your house, your land, and you say that I give you 5,000 and you give me a car, and if I give you that for 5,000 and you give me that car, I don't expect you to come back and you retract. Because you looked at 5,000 to be sufficient to the car. So it's not a must that the consideration must be fair or equal in value. We are going to be looking at the case of Thomas versus Thomas.
That must be sufficient, but no need
to be adequate. Counsel, when you look at that case of Thomas versus Thomas, the plaintiff went and mortgaged his cottage at just £1, you can imagine. And after mortgaging it at £1, his cottage, he came and started claiming that they had given him little money. And akasete kali katono. Munzirize cottage ya njagala.
Banji nyo babikola nga bamaze okutunda ne befuula.
So the law does not allow it. It's not a must. It does not mean that to give your phone, you have to give me a carton of ice cream. Even if you just, if I say that, please give me an ice cream of 500 and I give you a phone, I'm looking at an ice cream of 500 to be sufficient to do the phone. So it's not a must that consideration must be fair or equal in value. But then we shall be looking at circumstances. That rule, it has exceptions. We have circumstances that do not amount to sufficient consideration. And here we are going to be looking at part payment. Part payment into obonsa sudeko chitundu tonsa sude zona. Right? And part payment is going to be taking it to what we call the penalty rule. So what does the penalty rule say, counsel? The lesser sum does not amount to a bigger sum on the day of satisfaction.
I beg your pardon?
The lesser sum does not amount to a bigger sum on the day of satisfaction. For example, the lesser sum, a sentence to no sum si sente. The lesser sum does not amount to a bigger sum. The sentence on the principal sum on the day of satisfaction.
What is the day of satisfaction?
The day you've agreed to make payment. For example, counsel, ombanje mitwalo 10. You are demanding me 100,000. 100,000 you are demanding me. It becomes the what? The greater sum. We are going to kusasuredi.
Monday.
Monday next week. Now Monday next week it becomes the day of satisfaction, which is Monday.
Yes.
So on Monday next week, how much do you expect me to pay you?
100,000.
100,000. So if I pay money that is less than 100,000, will I have paid you the 1,000?
No.
So that's why we're saying that the lesser sum, a sentence to no, does not mean the greater sum. On the day of satisfaction, meaning, kumanda next week, but what it does not mean Mbubanko what the sentence on now. Command over your government to Alukumi. But counsel, we have exceptions to that rule. Whereby, even if you are demanding me 100,000 and I pay 1,000, even if you are demanding me 100,000, but then there are some circumstances whereby I can pay 500,000 and I will not pay the balance. Those are exceptions. We call them common exceptions to the that rule of the rule of penalty rule. Now, one, where the creditor requests the debtor to pay him on an earlier day of payment, Meaning, you've agreed that the 100,000, you want it on Monday next week. But then you get a problem, you come before Monday reaching and you say, please, I've got a visitor and I found out in my house I don't have salt on that 100,000 that I'm demanding you. Can you give me 1,000 and I go and pay what? And I go and buy the salt. As long as you've demanded that money before the dog payment of Monday reaching, if I give you that 1,000, the 99,000, I cannot pay it to you. Bank mazeyo. Now those are the exceptions whereby the lesser sum will amount to a bigger sum. But remember, we're saying that the general rule says that the lesser sum does not amount to a greater sum on the day of satisfaction.
Bakasetting at Batiabuka principle.
Nanti kakati tuno kugobera why?
Because is when ngamba mukubanja siringi 10. Olunaku lwe twakkaanyako lwa Monday terunatuuka. Ne nfunamu obuzibu. Ne ngamba soko mpeeyo esiringi 2.
Aha.
Okiwulidde alize kyendimu. Kitegeeza nti ziri zonna zifudde.
Ziba zifudde bato kyazibanye. You weren't patient enough. You came before the dog paying your bills. Meaning nango.
Before the dog satisfaction.
Meaning nango ayingide mu mbalira yango wati nange nageze neze wololinga yagazite kama mako. So you have to wait for the day of satisfaction. And also we shall look at the intention of the parties. Then secondly,
as we finish
as we are summarizing it, another one is that where the creditor changes the location of payment, the place of location for payment. We've agreed that the money I'll pay from Machindi. Then I reach at Machindi. I come with your money. Then you tell me, please, I got an emergency. I didn't call you. I didn't have battery. I'm in Masaka. Can you bring that money to Masaka? At the end of the day, council, I will not touch in my expenses. If I'm bringing the money to Masaka, where's the Zenyini? On that 100,000, I'll remove the money to Masaka, the money to bring me back, and then meaning the money I will pay you to be less than 100,000.
Yeah.
Another exception. Another exception is where something is being offered for another thing other than money. Instead of giving 100,000, I give you something that is equivalent to that. For example, I have a shop, I'm saying rice. You're in hostel, you are demanding 100,000. But then time reaches and you say, please, instead of 100,000 I'm demanding, you give me the rice for 100,000. I go and I stock in my room. Now, I don't expect you to come back and demand that money because the rice I will have given you, we presume that I converted it into what?
Into money.
Into money, so you cannot come back. The fourth exception, where third parties pay the creditor on behalf of the debtor. In the case you go over and me the person you are demanding me, I don't have capacity to pay you. Yes. But I can talk to my reverend, my girlfriend, my wife, my mother, my best friend, my lecturer, and he pays you on my behalf. We don't expect you to come back and demand me. Into me, I'll fight to pay. But then another person has paid you on my behalf. Then don't come back tomorrow demand me the same money. Because under section 14 of the Contract Act, we have what we call fraud. We shall know that this person is just obtaining money by false pretense.
Section 14.
Section 14. I think it talks about fraud.
14. Fraud.
So it's not good.
Consent is induced by fraud where any of the following acts is committed by a party to a contract, or with the convenience of that party, or by the agents of that party, with intent of deceiving the other party to the contract, or the agent of other party, or to induce the other party to enter into the contract.
Yes, kati bwe njani nkusasula ngobadde obanja sister wange nene ngamba tayina sente omubanja mmeka 15 nenzikuwa no genda, then don't come and demand my sister. What me have paid you on behalf of what? My sister. Once you do it, that's fraud.
So you become the third party. You pay, so you cannot come.
You cannot come.
Oh.
Check it. So,
okay.
Colleagues, that's what we can say for now. Then maybe the next episode, the next meeting, we shall be looking at capacity, we shall be looking at legal intentions and consent. Yes. And then capacity is very interesting. Maybe if I can give you the highlight, we shall look at Article 31 of the Constitution, we shall look at Article 34, Clause 4 and Clause 5 of the Constitution, we shall also look at Section 4 of SOGISA, we shall also look at Section 10 of the Contract Act, Section 10 subsection 2, Section 11 of the Contract Act. We shall be looking at those cases of Nash versus Innerman and Roberts versus Gray, like that. So the next meeting, join us.
Okay. Mwebale nnyo mwebale ddala bannange okubeerako. Naye tubadde mu byamateeka we bagiyita discussion. Tutera okubeera abangi naye leero mbadde ne council yekka. Mateeka bwe gatyo just tutogedde ku elements 3, ku elements omukaaga zitukubye 1 hour. Elements 3 olina okwogera principle, olina okwogera types, olina okwogera rules ezimanaginga principle eyo, olina okuleeta emisango egyali giwozeddwako mweyo embeera. Kakati byonna byonna mubitegedde kyebayita contracts law. Tukyatambula, tujja kukomawo tumalirize elements of valid contract, then ate tujja kubaleetayo ne ku criminal law nayo mulabe biki ebiri mu criminal law. Ndowooza tujja kudiscussing omusango gwokero, engeri abantu gye bakagugoberera. Fale tujja kuleetamu ebirungo ebirala bye bataalabye ebyamateeka.
Burden of proof. We shall be looking at presumption of innocence. That's Article 28, Clause 3, Paragraph A. We shall be looking at being represented by a lawyer at the expense of the state. That's Article 28, Clause 3, Paragraph E. So we shall sit down and we look at those things that other people that maybe were saying that what the state was doing was bad, and maybe we shall also see what the lawyers for the accused that they missed.
The reasoning of the lawyers.
And even what they missed to bring out.
Yes. No worries. Thank you very much. Thank you for following this page. Please continue to comment. If you're a student of law, if you're a father or a mother, a parent of any student of law, please follow follow our channel and get to know the things. Twesomesa fekka era oyinza okuba obadde oli stack eyo mu bintu ebyenjawulo n'oyigira wano. Yes, nange njigira mu bintu bingi nnyo, kati ekyaleero kiwedde, kati tugendagenda mu byobufuzi byaffe nga bulijjo. Mwebale nnyo, mwebale ddala, sebo mwebale okujja. Yes, tujja tandikira olunaku olulala.